Welcome to our event today, Democracies and International Law. I'm Sue Stokes. I'm the faculty director of the Chicago Center on Democracy and a professor of political science at the University of Chicago. The event is also co-organized by the Democratic Erosion consortium at Brown University. So today we have the honor of several distinguished panelists joining in to discuss the role of international law in strengthening democracy. And that is the topic of Professor Tom Ginsburg's new book. So we're excited to have this stellar group of panelists and excited to be able to spend some time talking and reflecting on my colleague's Tom's book. Now, before we begin, I want to encourage you to participate by asking questions. Please type your questions into the Q&A box at any time during the talk. And Rob Blair, who's going to be moderating the talk, will, I assume, sort of be monitoring the Q&A questions. The webinar is being recorded, and we will make it available. The recording will be available to you on the Chicago Center on Democracy's website, which is at democracy.uchicago.edu. So it gives me great pleasure to introduce our panelists. Tom Ginsburg is Leo Spitz Professor of International Law and Professor of Political Science at the University of Chicago. He focuses on comparative and international law from an interdisciplinary perspective. He's the author of Democracies and International Law, which was published, among many other publications, which was published this fall by Cambridge University Press. Rob Blair is our moderator for today's conversation. He is the Joukowsky Family Assistant Professor of Political Science and International and Public Affairs at Brown University. His research focuses on international intervention and the consolidation of state authority after civil war. He also directs the Democratic Erosion Project, which is a multi-university consortium that addresses the causes and consequences of democratic deconsolidation. Karen Alter is the Norman Dwight Harris Professor of International Relations and Professor of Political Science and Law at Northwestern University. Her research focuses on the construction of global economic rules regulating trade and money, and on the determinants of politically sustainable capitalism. Hélène Landemore is Professor of Political Science at Yale University. Her research and teaching interests include democratic theory, political epistemology, theories of justice, the philosophy of social sciences, particularly economics, constitutional processes and theories, and workplace democracy. Brad Roth is Professor of Law and Political Science at Wayne State University. He specializes in international law, comparative public law, and political and legal theory. So let me turn things over to Rob. Thank you very much.
Okay, thanks, Sue. Welcome, everybody. My name, again, is Rob Blair. I'm a professor in the Department of Political Science and the Watson Institute for International and Public Affairs at Brown University. And I'm also the coordinator of the Democratic Erosion Consortium, which is a network of more than 50 universities around the world that combines teaching and research and civic and policy engagement to help our students and faculty better understand threats to democracy in the US and abroad. We are delighted that so many of you could join us for this roundtable on Tom Ginsburg's excellent new book. So to start, I'm going to invite Tom to give about 10 minutes of remarks on the book. And then after that, our three panelists will each give about 10 minutes of comments. I'll invite Tom to respond briefly to one or two comments, and then we'll open the floor to Q&A. As Sue said, I have some questions for Tom prepared, but I'm much more interested in what the audience is interested in. So please drop your questions in the chat, and I'll round them up as we go. So with no further ado, Tom, the floor is yours.
Thank you so much, and thanks to everyone, the panelists and everyone in the audience for taking some time to join me today and talking about this new book, which was really motivated by a follow-on to a previous book I did on democratic backsliding and what constitutional law around the world could do about that. And so this is a natural extension, asking what international law can do. Now, international law may be somewhat unfamiliar to many of you, so I'll just briefly say that, it's classically conceived of as law among states. And a lot of international law sort of is state reinforcing. It emphasizes values like sovereignty, non-interference in each other's affairs, no threat or use of force across borders, to sort of reinforce state structure and not look inside states. But then since 1945, we've had quite a bit of international law, which is, you might call liberal international law, which has emphasized human rights and that individuals should actually have some rights on the international plane. And one of those rights that's in that literature or in those instruments is a right to participate, to run for office, and to vote in free and fair elections in the International Covenant of Civil and Political Rights. So basically, international law is a little bit schizophrenic here. It says, that people should be allowed to participate in their own government, but there's no, in my view, general right to democracy. And also, there's these other sort of rights of states to be free from interference from each other. So that's kind of the setup. And we've seen in recent years a number of instances in which after a coup or perhaps, in which states are increasingly taking an interest in the democratic quality of each other's governance. You have, for example, in the European Union, a whole new machinery that's been mobilized to deal with Hungary and Poland on the rule of law issues, major architectural change in the European Union. Hasn't really worked so far, but you see the mobilization of that. You have in West Africa a number of interventions, and more commonly like outcasting, I guess I could call it, situations where there's an unconstitutional change of government and that violates regional international law, and that leads to some sort of like suspension of the member state from a regional organization. And in my view, that has moderated a lot of the a number of potentially severe authoritarian turns. So you've got two things going on. My book is called Democracies and International Law. So what do I mean by that? What I'm trying to do is excuse me, empirically try to understand how democracies behave on the international plane. And that's a little bit different than looking at how democratic international law is or anything like that. Instead, I have a theory that's rooted kind of in, I suppose you'd say, credible commitments across time. Democratic governments know that they're going to leave office. That's the definition of democracy. And sometimes will just try to tie their successors' hands through making commitments to cooperate with other states. And there's a lot of reasons to think that democracies would be more likely to use the formal machinery of international law, treaties and such, and to be willing to delegate conflicts to third-party dispute resolution on the international plane. Democracies value transparency. Democracies tend to be responsive to their citizens' demands for public goods, which can be produced, in this case, across borders. So what I do in the book, and it's not, I should say, a rigorous causal test, but basically my strategy is to overwhelm you with evidence. I look at treaty making, and there's 15,000 treaties that I look at. I look at international adjudication before various international courts. I look at other sites of international lawmaking, like something called the International Law Commission or the United Nations Commission on Trade Law. And basically, to summarize all the empirical evidence, I find that in all of those instances, democracies are more likely to use the machinery of international law. So they're about 20 times, looking at bilateral treaties between two states, are about 20 times more common among two democracies than they are among two dictatorships. Even though, of course, they're only about 40% of country years have been democratic since World War II. Looking at multilateral treaties, you have the same thing. I actually, to sort of isolate some of the causal factors, I look at countries that switch back and forth between democracy and dictatorship, and I show that those countries are more likely to sign treaties when they are actually in their democratic phases than in their authoritarian phase. And then looking at dispute resolution, they're more likely to go to the International Court of Justice. Almost every case filed before something called the International Tribunal of the Law of the Sea, relatively new tribunal, but very technical, involving maritime boundaries and such. Those are almost all filed by democracies. And in these international fora, you see that democracies are much more likely to speak up and get their opinions voiced. Now, we're in an era of democratic backsliding. One way to think about that is that, non-democracies have started to use the machinery of democracy and the appearance of democracy in order to sort of hide their basically authoritarian purposes. So the modal, non-democratic regime now has elections, has a constitution with a long list of rights, have courts that are nominally independent and might even be independent in some realms. And so that suggests basically a strategy of mimicry, which is something that we found in our work on constitutions, that, that democratic innovation starts in democracies, but then it gets copied and mimicked by authoritarian regimes. And I show that authoritarian regimes have done this with regard to international law, and now in particular, are actually quite affirmatively cooperating in what I call authoritarian international law. That's the use of international law to extend authoritarian rule across time and space. And as you might guess, China is a major player here. China's become a huge force at the United Nations. That's accelerated under the last few years when the United States basically, walked out of a bunch of international fora. Russia as well has become a major international player. And together they sort of, as Karen has recently written about, will often act together in making joint statements. And so I argue that this is actually has substantive implications. It's not just, fig leaf kind of stuff. It's reinforcing that view of sovereignty, notwithstanding the fact that those two states are often interfering in the internal affairs of other states, and basically acting, setting up kind of defensive vision of international law, co-opting concepts. This week, of course, the Summit for Democracies, I guess it's today. And just this week, last Sunday, the Chinese government issued its own statement of democracy, saying democracy is a universal value. But we shouldn't criticize, there's not one vision of democracy. Nevertheless, we're going to offer our opinion about American democracy. And they have a long list of, critiques of American democracy, many of which are accurate. But that just shows you that there's this kind of consensus and watering down of the term in order to advance, obviously, an authoritarian regime. And so that's a source of great concern. I basically argue that at the end of the day, international law is going to survive. I mean, besides China and the United States, which tend to have very hegemonic attitudes towards international law, there's a rise of regional organizations, there's a rise of smaller powers, and there's a lot of space and a lot of action, actually, in which these countries will become the critical force. For those of you who are studying democratic backsliding, the dynamics are primarily domestic. But then at the margin, you can see that sort of the pro-democratic forces can be assisted or get a little helping hand from international actors at critical times. And I think we see that over and over. And so normatively, what should we do? I think we should obviously reinforce that democracy supporting international law, not going so far, I call it preservative democracy support, not like going and invading countries and imposing democracy. That's a crazy proposition because not every country can be a democracy. But instead to recognize that there are a lot of steps that can be taken at the technical level and at the political level to support, the wavering democracies. At the end of the day, I think international law has been used by democracies because it helps them create public goods for their own citizens. And in that sense, international law is actually, good for democracies. Good if more countries are democracies, to be sure. But even if we can't cooperate on, as Biden is talking about, some kind of community of democracies or something like that, even if that never comes to be, international law is a mechanism that indirectly supports democracy when it helps democracies create public goods, right? When they get trade benefits or more security or environmental protection. And because that kind of substantive use of international law has been dominated by democracies, I think that it will continue to be a kind of force. But we should definitely thicken and strengthen the genuinely pro-democratic parts of the system, particularly in an era of democratic backsliding. So that's my 10-minute summary of the 200-something page book. Thanks so much, Rob. I'll turn it back to you.
Wonderful. Thank you, Tom. I'm going to turn it over to Karen now for her roughly 10 minutes of remarks.
Hi, I'm really happy to be here and to have read this wonderful book. I'm going to begin with some gushing because, Tom can be a little understated and humble. And so I got to tell you, this is a really great book. When you read it, you're in the hands of a master. He knows exactly what he's doing. He knows what his theories and methods can and cannot do. He knows how law and politics work. the careful theorizing, the nuance, the structure of the book, the foreshadowing, the jumping back and forth. You just know that you are in the hands of someone who's really skilled. But it's also a book that just is something that only Tom Ginsburg could write, because it weaves together topics that he's been researching, writing, and teaching about throughout his career. And these include the law and politics of authoritarian regimes, including China. So it's really, I think, as interesting as a statement about authoritarian and international law as it is about democracy and international law. It includes his insights on the diffusion of judicial review, transnational constitutional convergence, and constitutional change, how international human rights instruments have been influencing national constitutions, his recent work with Aziz Huq about democratic backsliding and democratic decay. And it also imbricates a lot of political theory and legal theory, which is why this panel has a lot of theorists on it. And these are all present throughout the book. And in that sense, the book is kind of a meta study, both of the issues that Tom has been working on, but also he gathered together so many different data sources to explore his insights about democracy and international law. And so throughout, it's like a meta study of what we've learned empirically about human rights and international law, when it works, about democracies and international law. It's really wonderful. There's also a lot that's truly new and original in the book. As I said, he's merged all these data sources to investigate how democracies engage international law. There's a review of regional systems in Europe, Latin America, and Africa as they protect and promote democracy. And he's been keeping a keen eye on China's use of international law. So it's incredibly up to date and brimming with recent examples. I keep my eye on it too, but not to the extent of Tom. So I learned a lot from the examples that he has within it. This is a more eclectic theorizing book that I've ever seen Tom do. In articles, you know, you kind of stay in a similar style, and some of his books stay in a similar style. I'm generalizing here because who could possibly have read everything that Tom has written? So for the stuff that I've written, it was the most eclectic theorizing. The core of the theorizing about democracies and authoritarian analysis is built around the theoretical assumption of regime preservation, that regimes seek preservation. He called it credible commitments, but it's also to preserve the policies and goals that they had. And I'm going to push on what's left out because of this assumption. But so it has this theoretical core where he deductively then defines a lot of corollaries. It has numerous methods. It has large end analysis, mostly descriptive statistics, a few regressions, some event analysis to see how key events become pivot points, a pretty optimistic qualitative analysis about how international law through regional mechanisms might help promote and save democracy and stem democratic backsliding. And he has the empirical studies of behavioral patterns, historical institutional analysis, sequencing and layering, qualitative cross-case comparisons, counterfactual musings. And throughout, he identifies how contingency is always present. So we know that it's not that these trends that he's studying are determinative. There's so many contingent events that he constantly reminds us about. For example, China joining the WTO, the post-Cold War Washington consensus, which led to neoliberalism run amok, the Iraq War and its aftermath. He has this wonderful fiction of what might have happened if Bill Clinton rather than Ronald Reagan got to replace Supreme Court Justice Powell, which leads to a cascade effect from the Bush v. Gore ruling all the way down. He has COVID in his distractions. He has many, many contingent examples where he keeps reminding us that things could go a different way. I call this eclectic theorizing, which is what Peter Katzenstein uses when he talks about theorizing that trespasses deliberately and liberally across competing research traditions with the intention of defining and exploring substantive problems in original and creative ways. Tom actually calls this emergent analytics, adopting Gregory Schaefer's idea that, and it's an approach that oscillates between empirical findings, abstract theorizing, real world assessments, and back again. I see why Tom prefers the emergent analytics, because the last part of the book is all about imagining what might happen. But of course, what might happen is contingent, because China will make a move and then other countries will make a counter move. And so he's just trying to think about in an iterative way what might happen. So the bottom line is it's a really fantastic book that I really recommend. I want to, in my remaining time, which I'm probably going to go a little over, is ponder 4 issues. What's outside of the lens because of his regime preservation theorizing? How should we think about the role of judicial decisions in his analysis? That's the second. what role legal scholars and lawyers have in the world that Tom describes, because in particular, what do we lose when scholars accept lowest common denominator legal pluralism rather than striving for higher universalistic international law? And when you add these 3 points, you get to a theory that is mostly interest-driven and empirical and rear-view window looking. And so what ideational vision then should we be supporting? We don't necessarily have a map from this book. So first, what's outside the lens because of the regime preservation theorizing? So chapter 2 asks, why would democracies be different? And his answer is a mixture of Kant and deductive theorizing. So he has from Kant that democracies interact differently with each other in terms of dyads. He accepts Kant's explanation about how transparency or publicity and the social contract in a league of democracies might behave differently vis-a-vis each other. And he embraces the benefits of liberal values, human rights, free speech, freedom of assembly. That said, the heart of the theory is an interest-based argument about regime survival, and all of the deductive corollaries come from that. This idea of regime survival, Ginsburg notes, plays out differently for authoritarian regimes and democracies, so they survive in different ways. But both democracies and authoritarian regimes seek regime survival, and he wants democracies to seek more robustly their survival. I'm not going to repeat the argument because my question is what's left out. And to be fair, he does say that democracy is baked into international law in certain ways, in the ways that he just summarized. But I think that his empirical orientation gets a bit in the way here. So I agree with Tom that the good of liberal democracies that they've been selling looks extremely tarnished. He's made peace with regime survival to avoid democratic backsliding. So he wants regime survival because he wants us to more robustly commit to it. But I have a hard time giving up the idea that ideas and beliefs are important motivators of people. And I have a very hard time accepting the Chinese formula of international law, which is the UN system plus sovereignty protection. So if the definition of an authoritarian regime is that the government or the group of elites want to stay in power, that's a version of regime survival that liberal democratic theory doesn't accept as a legitimate basis of governments. Ginsburg wants democracies to promote regime survival, and he recognizes that democracies also evangelize about the universal benefits of democracy and that hasn't gone so well. And he only thinks we should do that when it has a chance to be successful. But where this leads Ginsburg, one could say, is a support light for the democratic elements of international law. Like, I don't know where he stands on Ingrid Wirth's idea that we should actually give up international human rights in order to make international law more sustainable. There isn't kind of an ideational heart left in international law stories. He says he's neutral about international law, that it can be a force that pushes in many ways. But I think you need a vision of international law in order to make it attractive to people and to the participants who are going to push for international law. So that's my first point. My second point, though, is how should we think about the role of judicial decisions in analysis? Because when he switches over to looking at democracy preservation, he then starts looking at regional mechanisms and what they have done to try to preserve democracy. And a lot of that discussion comes down to judicial decisions, although there's also some collective action. I think Ginsburg would agree that judicial incentives, legal community incentives are very different from political interests and regime survival incentives. So when he turns to the regional mechanisms, it's a pretty big analytical shift, and kind of the regime survival interest-based analysis is no longer there. You have regimes that are, the regional stories are less of a club of governments that are operating to protect themselves and their values. It's more into the world that I studied for a long time when I studied international courts and how they become effective. The regional mechanism works because there are independent judges who can make decisions that political leaders would not make. Maybe judges become the last line of defense because political actors fail to act robustly to defend the democracy elements of the regional agreements. And so the decisions of these international judges matter to the extent that they connect with what I call compliance constituencies. And these constituencies include lawyers, activists, judges, government civil servants, military legal officers, diplomats, international institutional actors. You have to connect with these groups and motivate them to actually also want to push towards making the legal rulings effective. So this piece of the puzzle of how you're going to connect with these sub-state actors and motivate them to make a change is not really part of the theoretical core that Tom is putting forward in the book. So I want to hear him square that circle. If compliance constituencies are motivated by ideas about the principles embedded in constitutions, ideas about the principles embedded in international law, if international law reflects these principles and therefore inspires them, well, that's a very different mechanism than the regime survival assumption. So how do you fit those pieces together? My third point is, what is the role of legal scholars and lawyers in the world that Tom describes? You could say in the regional chapters, their role is to try to promote these democracy enhancing elements that are baked into the regional systems that he studies. But Tom seems to accept that authoritarian international law is ascendant. And yes, he wants people in democracies to fight harder to protect our democracies, but where is a universalistic vision of international law in this story? Is he suggesting that Western lawyers stop fighting for their ideals about what international law requires? Now, he's so nice in this book. He doesn't criticize many people, although he does say that Harold Coe is wrong when he thinks that transnational law is going to fend off Donald Trump. In the domestic realm, we often hear that liberals are too hand-wringing and too nice, and that the people on the right will make bolder statements and push obnoxiously and fight hard. He doesn't fight for the liberal elements of international law. He concedes he says, I think on balance that they're good, and that we don't even have to defend this idea that they're good. But he doesn't leave us with a vision of international law, because he also admits that the liberal international law is tarnished in how it's been used. So my final point is, what should we want? And this is really putting his empirical focus against an ideational focus. So of course, authoritarian international law does have some ideals, and the Chinese scholars and Xi Jinping are really spinning out right now all these really lovely sounding ideals about peace, about win-win relations, about a harmonious world, about alleviating poverty. I mean, they are really doubling down on trying to create an ideological core for international law, but that core is always linked to the UN system, which the Chinese are also colonizing, and where there are, of course, Security Council vetoes. So they're also shifting the core to a UN system where they're also trying to control. I think that thin international law that becomes mostly rhetorical, that doesn't really have enforcement capabilities in a politically penetrated UN system, I don't think this is an ideational vision that is going to inspire a lot of people. So while I agree that the liberal narrative is tarnished, I also think that the Chinese narrative isn't going to survive or be that convincing to these compliance constituencies, to these sub-state actors that need to be the ones who give heart to international law. Now, Tom points out that not all is happy in international relations in the legal world that China's engaging, that China is not making win-win agreements that everybody says, oh, this is just fantastic. But my sense is the Western international lawyers are going to need to come up with a better vision than authoritarian international law, and an empirical analysis that inherently looks backward doesn't give you anywhere to go for this better vision. So to be provocative, let me identify two options, one which comes from Tom's book and one which is beyond that. One would be a historical civilizational narrative. Let me tip my hat to one of our great graduate students, Alisher Yuzgedbayev, who wrote a wonderful paper actually critiquing Tom's brand new book. And he makes this point very strongly. Now, Ginsburg discusses Chinese discourses, I'm going to mispronounce this, on Shaksha, I don't know how to pronounce that, all under heaven, which may actually be inspiring Chinese leaders today. That's when they go back to their historical civilization and try to come up with an idea which is based kind of on hierarchy and on kowtowing to China's superiority. That's not going to be very appealing. And while I don't want to go full class of civilizations, if we ended up with a Western way of thinking about international law, and maybe an Islamic way of thinking about international law, and maybe a Chinese way of thinking about international law, that could be a pluralistic set of visions that don't necessarily cohere. We're more in Anthea Roberts' world of, is international law really international? And then the alternative, I think, is what Chris Roy Smith talks about, the moral purpose of the state, that each state really needs a truly moral narrative that holds it together. Now, Xi Jinping is making this narrative, and Chris Roy Smith thinks that these narratives add up to constitutional structures in the international system. And if we go to what Tom tells us, it's regime preservation, a club of states, authoritarian democracies, just defending an international law that helps them survive in the form that they want to survive in. I think, like Roy Smith, that you need a moral purpose that is going to inspire people, and that we can't go back to the old liberal formula because it's been misused and tarnished. So it has to come up with a new formula. The Chinese are trying to make one, and I think that the West has to offer it. The key is you have to actually live it. You can't just talk about it. So I would say we're in a moment where we need to come up with a new vision of international law that can actually inspire sub-state actors, the legal community, judges, and that Tom has conceded a bit too much in accepting regime preservation as in a thin, relatively thin version of international law, even though I think he comes to that position reluctantly. So I'm going to stop there.
Perfect. Thank you so much, Karen. I am now going to turn it over to Hélène.
Thank you, everyone. Thank you, Tom, for including me in this panel. I'm a normative political theorist, so while I tremendously enjoyed the empirical dimensions of the book, and in fact, I learned an enormous amount from it, in particular on China and international order, I will not really take the risk of questioning any of the facts and causal claims in it. And instead, I will offer what maybe will appear as more of an external critique, but maybe one that has some value. Actually, I'm not entirely sure what the implications are, but really, this was my immediate reaction from the beginning of the book to the end. I have to open this conversation about the two main concepts at the center, democracy and liberalism. Because ultimately, I feel that this book has little to do with democracy in relation to international law, and a lot more to do with liberalism in relation to international law. And I'll try to say why I think this matters. And maybe I'm wrong, but this is something that I felt very strongly about. So there's a claim at the beginning of the book that, Tom is very aware of the distinction and that it takes the distinction very seriously, but I find that ultimately the book doesn't really take this distinction that seriously and tends to collapse one concept on the other. So let's say we mean, by democracy ruled by the people, ordinary citizen majorities, and by liberalism, an ideology centering individual rights and constitutional safeguards against abuses of power by tyrants, but also by majorities potentially. So when you combine those definitions, these relatively established definitions, very superficial ones, but sort of available, you get what's called liberal democracy, a regime that arguably combines the merits of popular rule without the dangers of the tyranny of the majority. So in other words, it's the best of all possible worlds, and I think that's what Tom is defending. But in fact, when you look at the definitions used in the book, so I've tried to sort of list them and compare them. I think the focus is mostly on liberalism. So let's consider the first one in the introduction. So it's a regime characterized by a government that has competitive elections. In the second element is a minimal set of rights to speech, association, and the ability to run for office. And those rights are protected for all on an equal basis. And finally, a third element is a system in which the rule of law governs administrations. Later in the book, Tom adds some additional features. So for example, transparency and accountability. So we get about 5 criteria maybe. But if you look at those 5 criteria, what is really the democratic one? Seems to me like the only one is the first one, the competitive elections dimension. because the other ones are liberalism in a nutshell. I mean, rights of speech, association, inclusion on equal basis. That to me strikes me as more belonging on the side of liberalism. And the third one is the rule of law. And the fourth and fifth one, transparency and accountability, are means and instruments of democracy, but they're actually more generally means of good governance. You could imagine the Chinese regime saying, look, we're going to be, we're going to try to be accountable and transparent. That wouldn't make them democratic. It would just mean that you would have a way to sort of like make sure they're doing the right thing for the right people. That doesn't mean they're democratic. So that begs the question, what do we mean by democracy again? If we don't just mean, a liberal regime that produces good governance. So again, for Tom, it seems to be the case that what's democratic here is the presence of periodic elections. So in my world, that assumption is getting criticized often because obviously, since Aristotle, we know that elections are actually an oligarchic selection mechanism. So it's actually empowering an elite class, typically a socioeconomic elite, and it doesn't distribute power equally. And there are some definitions of democracy as people power that are not compatible with an unequal distribution of power, even if there's rotation and accountability and transparency and all of these other good things. So there's a question here which is never answered. So why do we stick to this definition of democracy throughout the book? And there's a mild defense at one point, which is that, well, it's consistent with definitions found in international legal instruments. And also it's empirically tractable, which is great. These are great arguments. If you're doing empirical work, I accept that. But at the same time, from my perspective, these are not good arguments from a normative point of view. Just because everyone else says something does not make it right. Just because it's more tractable does not make it right. So for me, the point of a definition is to track not just existing usages of the term, but the truth about the regime form. Or if not the objective truth, which may be asking too much, at least an intersubjectively constructed, reasonable understanding of the term. So if everyone in international law said that the earth was flat, that wouldn't make it true. So you might say, well, the meaning of a regime type is not a fact of the world in the same sense as the roundness of the earth, but still, democracy etymologically means people's power. Historically, it didn't mean electoral regime at all. It meant being ruled and ruling in turn via open assemblies and popular juries. So there are other meanings out there that are never considered and that I think have credibility. So I think that a book about democracy could at least try to justify this choice of characteristics, if only against other empirical theories like Robert Dahl, for example, instead of relying on the basis of precedents or empirical convenience. So I'll be even more critical, if you permit. Later in the book, there's a definition of democracy as rule for the people, or at least majorities, and a sort of counter definition of authoritarianism as rule for the few. So it's on page 39, just to quote, the key differences between democracy and dictatorship lie in the size of the relevant groups of beneficiaries and the availability of information within the country. Democrats must satisfy a majority of voters and can be monitored by their constituents with relative ease. The set of people who matter is large, etc., etc. Whereas in a dictatorship, the set of people who matter is smaller and never approaches the majority of the society. So again, if I take my political theorist hat, I think that's not true. You go back to Aristotle, you have those definitions of this typology of regimes, and among the good regimes are the ones that rule for the people, basically for all of us, right? And they include oligarchies of all kinds and what you would call dictatorships. So you can have a dictatorship that rules for the people. In fact, that's what China supposedly does, and perhaps to a degree does, if it is true that it has lifted 800 million of people out of poverty. So I think it's kind of too convenient to define democracy as like, well, it's always for the people, whereas anything else is always for the few. And I spot a similar bias conversely in the way the international order is described, right? So on page 30, the expansion of international institutions in the 1990s appeared to be serving the interests of democratic publics with cosmopolitan preferences, so that the accompanying erosions of sovereignty reflected popular preferences. I mean, maybe I'm reading this wrong, but it sounds to me like, well, you know, if we ended up with a sort of neoliberal international order, it's out of democratic choice. But you could have a populist reading, which is no, it was in fact liberal elites leading those so-called democracies who've built this liberal international order, leading to a loss of sovereignty for majorities as long as it benefited them. So it's basically the winners of globalization created a world that served them because they were in power in all these sort of democracies, right? So I'm playing devil's advocate. I'm not sure I fully endorse that view, but it has plausibility. That's why Trump won. That's why Brexit happened. So, and I don't see that completely addressed in the book. So again, of course, my own view of democracy is much less minimal. I would demand actual participation beyond electoral participation. And sometimes you gesture towards that, but it's, in practice, this is not what happens. We rarely have actual participation. We have delegation of power through electoral moments. So why does any of this matter? Maybe it doesn't matter. Maybe it doesn't matter that you call democracy something that I would call, I don't know what to call it actually, a liberal republic or a liberal oligarchy. This is maybe a good regime. Maybe it's better than the alternative, in which case it's fine. We just have to be clear about what we mean by those terms. But still, I think there are some problems with not addressing these definitional problems because one, and maybe again, it doesn't matter, but for that book, but we end up watering down the ideal of people's power and contributing to the self-aggrandizing mythology of, these 40% of countries that you talk about, which really do not, I mean, many of them, I don't think deserve that noble, descriptive characterization because they fail basic standards of democratic participation and empowerment. More importantly, I wonder, and that's more like a question that an empiricist can answer, but given the book purposes, isn't there something like a definitional trick at play in defining that the liberal international order fosters democracy, when in fact it fosters more liberal regimes, right? To me, it sounds like it's just liberalism or even neoliberalism all the way up and all the way down. That there's no gain in democracy at any point. There are gains in human rights, there are gains in freedoms, but not in democracy per se. Again, to play devil's advocate, the populists might well be right that our so-called democracies are in fact plutocracies, liberal plutocracies in disguise, where cosmopolitan elites promote an agenda that favors them and corporate donors at the expense of majorities and vulnerable minorities. Meanwhile, the demonized Chinese government, who does resist some of that liberal international order, is perhaps not democratic either, but at least it's capable of ruling for the people, even in violation of liberal rights. Okay, so to rephrase, I'll stop here, but to rephrase my criticism, I think it's a book that claims to be about democracy and international law, but really is about liberalism in international law. And what this book in the end makes me think is that liberalism is not just about the background conditions for freedom in a society or the background conditions for democracy. It might also include a type of regime and a type of governance, which we all call, even I sometimes call democracy, but that we really should more aptly call liberalocracy, electocracy, or even electoral oligarchy. Okay, I'll stop here. Thank you very much.
Terrific. Thanks so much, Hélène. And lastly, I will turn it over to Brad.
Thank you very much. Well, this is truly a hard act to follow in all respects here. First, with respect to Tom, of course, Karen has gone on at great length, but certainly insufficient length to talk about Tom's stature in the field and as a really leader in comparative public law. And this book is a remarkable exemplar of all of what he brings to bear in terms of methodology and in terms of a wide range of knowledge of different legal systems and how they intersect with the international legal system. So it's really a tour de force in that regard. I should say further, I think Karen and Hélène have both given really remarkable responses here. I will probably be doubling down on what Hélène has said, and I will probably be giving something of a counterpoint to what Karen has said. But I think that they both really go very directly to important points here. So what I want to say is basically three different things. First, to try to figure out, the issue of what exactly is international law's highest and best use, which is a kind of a question sort of begged by the book itself. Secondly, I want to talk about a conflation of three different phenomena that are associated with democracy that I think need to be disaggregated. And finally, I want to talk about the difficulties of the use of domestic constitutional law to establish who is the bearer of legal authority within a state for purposes of international law. That there has been this tendency, as Tom has pointed out, particularly at the regional level, to try to use domestic constitutional law as a means of identifying essentially usurper regimes. And I want to call into question whether that's a good idea fundamentally. So first, with respect to international law's highest and best use, I think there's a tremendous difference in sensibility of people dealing with international law based upon sort of when they came into this, what historical moment they took as sort of normality, and exactly what they thought international law might accomplish in a particular era. And I'm definitely someone who came to political consciousness in an earlier era and frankly became an international lawyer because of Nicaragua versus United States. And so that puts me in a rather different position than many people who seem to be very much oriented in their views about international law to the period that I always refer to as the period between 11/9 and 9/11. That is to say, 1989 to 2001, which seemed to me even at the time to be an exceptional period rather than a normal period. And it seems to me that even though the future has looked more like the past in many respects, that people are still in the field very much operating from assumptions that are forged in the period from 11/9 to 9/11. I think that for that reason, I find Tom's work refreshing because Tom doesn't reflect that sense of being stuck in a period that had a certain kind of optimism about a global order that I think, from my perspective, was never something to be optimistic about to start with, but which has become, I think, quite frustrated over time in any event. So the key question is sort of what is the highest and best use of international law? And my claim about this has always been that it's about the creation of a framework of accommodation among actors who do not share the same interests and the same values and who have differential levels of power and resources in the international system. And so I like that Tom's emphasis on the kinds of collective goods that can be established among different actors in these kinds of arrangements. And I see particularly the importance in international law of law as a brake on empowered righteousness, that the people who claim to speak for universal values have tended to be people who have had hegemony in the international system. They have tended to be able to obfuscate the ways in which their conception of global order serves their own interests. And so the international law, obviously as someone who came to international law from Nicaragua versus the United States, I obviously see international law much more in terms of what it has to accomplish by way of being a brake on great powers. Sovereignty, which is a phenomenon that exists embedded within international legal doctrine, not simply against international legality. A point I won't belabor at this point, but one that I speak to a lot. Sovereignty is something as a legal matter, which is of differential significance depending upon where you are on the power curve here. For poorer and weaker countries, sovereignty, as manifested in international legal doctrine, is of greater significance. Whereas as powerful states defend their interests not by reliance upon those aspects of international law, but through exercises of power and influence in other ways. There's a line famously from David Matrani about how the goal of international legal order needs to be not so much to keep people peacefully apart as to bring them actively together. And I would argue instead that bringing people actively together presupposes having kept them peacefully apart. That in fact, in order for weak states to be willing to sort of take risks with respect to cooperation, that they need assurances with respect to fundamental principles in international law that protect their sovereign equality. So that's part one. Part two has to do with the way in which we use the term democracy. And my point about this is that there are three different concepts that this ought to be broken out into for purposes of this discussion. The first has to do with popular sovereignty, the second with constitutionalism, and the third with what I would call substantive democracy. The third having much more to do with the things that Hélène has spoken to. So the popular sovereignty issue ultimately, from the standpoint of international law, goes to this question of what apparatus has legal capacity to assert rights, incur obligations, confer immunities, exercise powers on behalf of the underlying bearer of legal personality, the state. And so the issue that arises in international law is how to identify the bearer of that capacity. And the question then is to what extent international law incorporates some conception of democratic legitimacy into that determination. This is something that Tom and I have discussed at great length in many contexts. The key question here is goes really to the core of international rights and obligations, because it's very different. It's one thing to attempt to sanction a state for breach of an international legal norm or to suspend its participation in a regional organization. It's quite another thing to say that the breaching act is null and void, and therefore that what purports to be the government is not, and that some other group of people actually represent the legitimate bearers of sovereign capacity on the part on behalf of the state. And that is extraordinarily destabilizing, and of course can lead to intervention by invitation in ways that I don't think I need to detail at the moment. So that's one piece of it. A second piece of it is the matter of constitutionalism. And I think constitutionalism, this discourse of constitutionalism is a little bit parochial in the way that people generally load it down with external norms pertaining both to liberalism and to democracy, when I think it's more useful to see constitutionalism as performing the function of creating conditions for peace and cooperation among a plurality of efficacious local actors, however efficacious they might be, it being the crucial question, because it's about accommodating that efficacy ultimately much more than it is pursuing substantive values about liberty and democracy. In order to have an effective constitutional order, one needs to have a broadly acknowledged framework for the legitimate exercise of power from which can be derived procedural and substantive limitations on power's legitimate exercise. This is something that is a major trick to accomplish in divided societies, something that is always potentially subject to peril. And it has a certain kind of value, but one should not assume that whatever is successful in that regard is necessarily comporting with some external standard, whether an international legal standard or some other kind of moral standard, with respect to questions of political justice or democratic legitimacy. It rather is a matter of the function of being able to maintain the kind of accord that's necessary in any given moment. The third piece then, with respect to this, is substantive democracy, which has to do in some way with establishing meaningful political equality. And the problem is that people don't agree on what that is. And so shooting wars have been fought over the very meaning of this idea. And informed persons of good faith and sound reason come to different conclusions about this because they contextualize the same information frequently in very different ways. But what counts as substantive democracy clearly can go far beyond anything that is established in the kind of procedural terms that Tom refers to in his book. And I totally agree with the points that Hélène makes about this. One thing too is there a kind of a bias toward what can be operationalized. This is brilliantly revealed in some sense in the opening pages of Samuel Huntington's The Third Wave, where he dismisses any discussion about the underlying purposes of democracy or about democracy as being having something to do with the will of the people, because these are ideas that can't be operationalized. So we're this sort of like the drunk in the lamppost here, but we're gonna examine what it is that we can test for here, and that makes perfect sense if it's the case, as Huntington asserted, that democracy is just one of many values. But the problem is, first of all, is there's something disingenuous about that to start with, and secondly, that it doesn't work that way when you have a normative overlay to this, where you're measuring the legitimacy of governments based upon their comporting with these particular standards. The third thing that I want then to get to is this problem of identifying the bearer of legal capacity with respect to the question of the domestic constitutional order, because the assumption that we see, and the Honduran case is one that Tom and I have discussed. It comes up prominently in the book, I think, in a couple of places. The difficulty is that the international legal order, at least as designed in the UN framework, is not a legal order of legal orders. It is a legal order of political communities that have the sovereign capacity to overthrow their constitutional orders. And so the very idea that each state has the inalienable right to choose its political, economic, social, and cultural systems without interference in any form by any other state, blah, blah, blah. This thing is, which is derived from a notion of the self-determination of peoples. So the sense is that as long as we can authentically identify the will of the people, with respect to these questions, that constitutional orders can come and go with international law, not taking any particular account of the fact that the domestic law has been breached. Even putting that aside, though, authentic interpretation of a domestic constitutional order from the outside is a highly dubious endeavor. It assumes that there's some there with respect to the constitutional law of a given state, when in fact, it doesn't take much introspection in terms of the way in which we talk about constitutional law in the United States to recognize that what the Constitution means depends upon who it is that's interpreting it and what their interests and values are. And so to try to determine what the Honduran Constitution said about Zelaya's actions or his removal seemed to me to be something of a fool's errand in that circumstance. I think it's also important to recognize then I'll conclude with this, that the constitutional orders are breached for various reasons when the stakes of politics, and this is something that Tom speaks to a great deal, when the stakes of politics become too high for the constitutional order to effectively mediate the social clash. And so the problem is that under those circumstances, that people frequently reasonably see a threat to existential interests that come from outcomes of constitutional processes. And it is not automatically the case that the failure to adhere to constitutional processes is a breach of some externally significant norm, whether from the standpoint of international law, from the standpoint of international political morality. So I think it's important to be skeptical of these things. But all that having been said, it is the very pluralism of Tom's book that attracts me to it. And I think it really is a wonderful exploration of international law from different perspectives in the international system, including the authoritarian one. So thank you.
Wonderful, thank you, Brad. So Tom, I'd like to give you a few minutes to respond to whichever comments, you can pick this up wherever you'd like. And while you do, I just want to remind the audience, if you have questions for Tom, please do drop them in the chat and I will ask them. Thanks.
Yeah, so I will be pretty brief because I don't think I can answer all of those wonderful, wonderful comments. I'm really honored that you all wrestled with this. Where to start? Well, I guess just to be clear, maybe I'll start with Kim. So she thinks I need, I won't answer all the very good questions you raised, but I'm not sure I need a thicker vision of international law other than the one Brad articulated. And maybe that's just a matter of, I should just explain as a matter of intellectual biography. When I was studying international law in the late 1990s, there was kind of a mood among international lawyers, like if only states would just comply with international law, everything would be better. And if we were to talk about the role of self-interest in compliance, that would somehow, weaken states' incentive to comply with international law and to use it. So in other words, international legalism became a kind of ideology of its own. And I've always been pretty skeptical of that. I do think, democracy, or we could call it liberalism for the moment, is a substantive value. And so if I was to put my stamp on it, I am a small L liberal. I'm in fact the last one left in the United States, but I am. And I think that, the point being, though, that if you're going to use this machinery of international law, you have to be quite conscious empirically about what it can and cannot do, or you get, disastrous interventions such as we've had. And so I think that's all I guess my own view about it. I look forward to talking with Alisher more about historical civilizational approaches. There are, of course, we are in a world of Western international law. That's the dominant system. But of course, within that, we have massive disagreements between Europe and the United States over, many of these issues, not to mention many, many others. And so I don't know that there's a civilizational even content to it, except that the structure is definitely civilizational. And now, in origin, and now we have China utilizing it for its own ends quite effectively. When I was hoping that Hélène would come up with the normative vision of international law for me, but instead she did quite incisively. In fact, I think the technical word here is touché, because the book had a subtitle until about the last couple of months, and the subtitle was "The Trials of Liberalism." And I had a long section in the beginning, dealing with liberalism and democracy in response to a critique I got. I just decided to jettison the liberalism thing. But I think you're right that is in fact what I am concerned with. That is, my definition of democracy is kind of maybe the beltway or policy wonk definition of democracy, maybe even the person on the street definition of democracy, but not a technical or theoretically grounded one in that sense. But my construct, which I took from my book with Aziz Haq, is, in that book we call it constitutional liberal democracy. So I recognize that it is a liberal definition, and my measures, to the extent, those of you who are political scientists, I'm using the VDEM liberal democracy measure. So there's a kind of, it might not be as incongruous as you think in the actual application. Yeah, so, and I do think that, your narrative you gave at the very end, that there's a kind of agency problem that happened with liberalism, right? You had elites basically constructing a liberal international order, which benefited those elites and lots of other people too. Let's not forget the 500 million Chinese lifted out of poverty. That then was viewed as kind of an agency problem precisely from the point of view of democratic publics in the West, precisely because it nominally took so many things off the table. The famous logic of, there's no alternative. We just have to keep doing this globalization stuff. And, God bless Donald Trump. We didn't have to keep doing it, it turns out. So, all right. So anyway, that was really, I don't have much to beat back your comments, but I accept them. In terms of Brad's very rich comments, with lots of stuff, I'll just say, where do Brad and I really disagree? I think one thing is obviously on this point he was making at the end about intervention. So Brad throughout his career has been very much a strong proponent of sovereignty, precisely because, as he says, it protects weaker states and it protects the ability, just be quite clear about this for the audience, that to protect, social projects or political projects, which might not be democratic or liberal, but might be good, right? You can imagine a socialist revolution in the context of Nicaragua, as he was talking about. We disagree about that case, but many, many social projects which are not democratic, which are still okay, right? And so there has to be space for those. So that's why he's a consistent defender of sovereignty. But I think the cases in which I talk about that soft democratic intervention hold up very well, and I would defend those interventions. The Gambia, I spent a lot of time on. The Gambia just had another election last week, and the person who replaced the former dictator won re-election. There's a lot of politics. It's a much, much, much freer place than it was 5 years ago, and I think that's a good thing. So maybe that's all I'll say, because I really would like to get some comments from the audience. I'll just stop there. But again, thanks to everyone for their wonderful comments.
Terrific. Thank you, Tom. So again, those in the audience, please do drop your questions in the chat. I'm going to start with one, and I'm maybe going to focus on something sort of more practical and empirical, just as my first question. So as someone who's spent a lot of time doing research in Africa, I was really struck by your discussion of the very important role that regional institutions have played in constraining at least some threats to democracy on the continent. And we can contrast that with the situation here in the US, where regional institutions seem to have had very little to say about our own potential democratic decline. So I guess first, for the benefit of those in the audience who haven't read your book, I was hoping you could just sort of briefly summarize your argument about regional institutions, and especially the role that they've played in Africa. But then, more important, I'd love for you to speculate as to what role regional institutions might be able to play in a context like the US, and maybe to put the question more concretely, perhaps you can share with us a sort of counterfactual vision of what January 6th and the aftermath might have looked like in a counterfactual version of the United States that was more embedded in regional institutions that had the sort of capacity that the institutions, that the African institutions that you describe have.
Great. Let me say a word about Africa, and that'll allow me to answer one of Karen's questions about the role of judges and legal scholars and ideas more generally. So, one very simple way to tell the story of what's happened in Africa this century is that there were massive conflicts in Africa, right? In 1990, Sierra Leone, the Congo Civil War, millions and millions of people dead. And there was also increasingly international legal machinery, the International Criminal Court, which was deciding, picking cases in Africa for most of its initial caseload. In the early 2000s, African states, which had long had regional aspirations, that dates back to colonialism or the post-colonial era, and so there's an idea there, but they begin to actually put some meat on the bones in the name of African solutions for African problems and to avoid these regional spillovers of violence. And leaders there were actually judges and bureaucrats, it turns out. But they leveraged a very important point, which is that the leaders of the various states, also had a general interest in good governance. They had an interest in their neighbors not having civil conflict. And they had an interest, interestingly enough, in avoiding unconstitutional changes in government, right? What is an unconstitutional change? That's like a coup or election that's set aside or something like that. And so, you know, sitting leaders don't want coups. They're most likely to be deposed not by the people, but even, you know, by another member of their inner circle. And so this just happened to sort of all come together, and a regional infrastructure was built up, and it's been used in many, many cases. I argue it's pretty effective, you know, and I can go into some details about it. But Rob asked the very interesting question: can we imagine the United States in something like that counterfactually? So the United States, of course, is a member of the Organization of American States. We are not a signatory to the American Convention on Human Rights, which would make us be before the jurisdiction of something called the Inter-American Court of Human Rights in Costa Rica. But we do occasionally get subjected to reports from something called the Inter-American Commission on Human Rights, which sits in DC. And so, you know, we do have some regional scrutiny over our behavior. Now, because of American politics and because we're a superpower, no one pays much attention to this. It doesn't make a difference. But suppose counterfactually that we were a signatory to, and you know, strongly embedded in a regional organization. Suppose further that the American public thought that was good, right? That we valued international cooperation and continental harmony and things like this. You know, then I think what would we have? We would have, in addition to the local processes of investigating the January 6th riots, we would have international actors scrutinizing our democracy in the same way that Brad was referring to international actors scrutinize the events in Honduras, which he was referring. And I think that's good. I mean, if democracies have an interest in other states being a democracy, we should be able to look at their internal democratic actions from the point of view of an evaluative standard, right? And just to say, yeah, this was consistent, this one was not. We need to do that in situations where it's unclear in his language who has the legal capacity to speak for the state, right? Where that's contested, we've got to make a judgment. You can't help it. So, and democracy should, when there are contested credentials and things like this, should focus on the democratic side of that domestic conflict. So all of that is to say that we could imagine a world where there were international reports and investigations, and at the margin, you know, maybe wouldn't make a difference, but at the margin, I think that would give some weight, some additional weight, possibly even some, you know, Canadian trade sanctions, if you can imagine that, or worse, a Mexican labor strike in the United States. I'm reminded of the movie of about 2 decades ago, The Day Without a Mexican, you know, showing up in LA and the whole country shut down. Our anti-immigration rhetoric forgets just how much we depend so much on immigration. So you can imagine there would actually be some actual sticks that would be used to coerce the United States back into a democratic path, obviously without any kind of military.
Terrific, thanks, Tom. So maybe picking up on part of your answer there, and you speak at length in the book about the role of hegemony in your argument, and the fact that hegemons can often manipulate international law in ways that less powerful states can't. And so I want to maybe I'll put it in the most provocative way possible, but I'm wondering if international law ultimately is really just a tool for constraining the actions of weak states. And I wonder if that's part of the reason why, for example, regional institutions in Africa have been more effective than an institution like the OAS, precisely because states in Africa tend to be weaker and therefore perhaps more susceptible to the sorts of pressures that those sorts of institutions can bring to bear. And if international law is really ultimately just a mechanism for constraining weak states, you know, I guess I'm left somewhat skeptical that it's really going to be much of a tool at all for protecting the sorts of backsliding, for protecting against the sorts of backsliding that we're seeing today.
Yeah, so in the book, I have a whole chapter on the United States and China, which Karen was referring to, and you know, it's this world's most powerful dictatorship, world's most powerful democracy for the moment, and their interaction obviously is going to shape the environment for a lot of other states. But on the other hand, their joint power is, you know, not as great as one might think, and there's lots of room for other actors. My somewhat counterintuitive argument is the United States and China actually act very similarly when it comes to international law, which is basically, as Rob said, international law is for the little guy. We don't have to, be constrained. We don't have to show up at proceedings if we don't want to. We can withdraw from stuff at will. And despite, sort of rhetorical support, often not actually any real constraint. Now, I suppose a critique is if that's true for the United States and China, that could be, true all the way down at every regional level. There's a powerful actor and such. But I kind of dodge that point and instead say that, to flip around your question, Rob, if you have a bunch of weak states, it's not that the international law is constraining them, it's that they can do something together they couldn't do otherwise through that constraint, which is that they can ensure that their neighbors aren't going to fall apart. And so it's an empowering mechanism, not a constraining one, even though obviously there might be some, constraint that come from that. So I view it as a, that at least the way I write the book is that it works for most states and most states comply most of the time. But, there are these two very large, powerful actors. It may be normatively as an international relations matter, but the world is better off with this kind of current, bipolar world, multipolar world, certainly than the unipolar one for reasons Brad articulated. The unipolar world doesn't end to me with 9/11. It ends with 2003, with the Iraq War, which was a luxury war, which is, caused untold suffering here and abroad. But that was precisely possible because there was no counterweight. So, a bipolar world or better means that the people who ever happen to be in charge for the moment can't make civilization ending mistakes.
Sue, I see you wanted to jump in. Do you want to ask a question of Tom?
Actually, I was going to cheat and respond to Hélène, but you can rule that out of order.
Please.
Okay.
I need all the help I can get, please.
So I think that I first of all, I miss my former colleague Hélène. I think we had many conversations along these lines when we were colleagues at Yale, and it's fun to continue the debate. So would-be autocrats, aspiring autocrats around the world make arguments about the shabbiness of democracy that are, to me, uncomfortably similar to the argument that you made. There are all kinds of problems with these democracies. They argue, therefore, not much is lost if we violate them. Not much is lost. Elections are always rigged. If I lose, says Donald Trump, therefore, his colleagues who know very well that he lost the 2020 election can say to themselves, well, it's a crappy democracy to start with. The Democrats are really terrible. And so on. Hugo Chavez went around before he was first elected president saying he sounded like Rousseau. In fact, he invoked Rousseau and said, the judiciary lacks legitimacy, the presidency lacks legitimacy, the legislature lacks legitimacy. They're not really a government. They're not only not a government of the people, there's no state, he went on to say. I think there's a very strong case to be made for celebrating systems that protect the people's collective right to fire incumbents in free and fair elections, and where they're, add all the liberal kind of institutional arrangements you like. I mean, we're all for them. I'm sure we all are. China, 1 million Uyghurs basically in concentration camps, no protected right for participation, for popular participation. In fact, a great deal of state resources poured into monitoring and forestalling any kind of popular collective action. So pretty dangerous to call that a kind of a substitute for democracy. Furthermore, when it comes to participation, I think what we care about is not whether people are participating in non-electoral ways, because they often are participating. So how do we code Egypt if that's our measure of what's a democracy? Did it become a democracy around January 25th 2011, no, it was an autocracy, and people were protesting very bravely against that autocracy. So I think what we care about is protection, effective protections of the right to assemble, the right to organize, the right to free individual and collective expression. So that's my diatribe, a friendly diatribe.
I don't
Go
want
ahead, Hélène. No, please
I
go
don't want
ahead.
this to become a discussion. Should I answer?
No, I'd love it. Yeah, please do. I'd love it to be a conversation.
I think, I mean, I largely agree. I wasn't, trying to defend China's human rights violation by any means. I just think that just because populists, use the weaknesses of democracies to undermine them, doesn't mean some of their criticism are not true. Like there are uncomfortable truths that are still truth, and then it's all a matter of how do you use them, for what purposes, in what context, and with what kind of solutions as alternatives. So that's what that's what I want to say, and I don't want to preempt the conclusion by Tom.
Well, just one of the things that I think I heard you say, and I think I may have misunderstood, but that I don't think is an accepted general truth, is that elections in democratic systems can only empower a kind of middle class, that they have this, in the Aristotelian sense, aristocratic element either. I think that's very variable. It depends on a lot of things. It certainly depends on institutions like, or systems like compulsory voting, and the ways in which people are allowed and encouraged to vote. So I think that it's certainly true sometimes in some places, but it's not inherent in the mechanism of.
Okay, so we have a real disagreement, but I think we've already explored it in the previous session on Jan Werner Müller's book. I do think that there is a intrinsic inherent bias in electoral systems, in that they distribute power unequally, and that if the definition of democracy requires equal distribution of power, then electoral selection mechanism will not allow for that, for the realization of the ideal. I'm not saying that makes for a bad regime. It just means that it makes for not a fully democratic, or perhaps not even a democratic regime. It might still be liberal and therefore desirable, but it depends on the definitions, basically. And that is actually quite, it's a theoretical point, but also one that you can trace all the way back to Aristotle. I don't think arguments of authority always apply, but in that case, it's a very valid point. So, but I think
I also don't want to dominate this discussion, but I just, one more question, maybe one more little back and forth. What do you mean when you say that elections distribute power unequally?
Well, human choice is not, going to give everyone the same chance to be elected. We're going to focus on salient characteristics like height, charisma, access to the media. It's conditioned by so many things, but in general, you will not have a sort of ruling and being ruled in turn that you get in a democracy in the Greek sense, where power is distributed on the basis of one person, one lottery ticket, which really is the closest you can get to equal distribution of power, assuming you also force people to participate, maybe, if you want to really be as close to equality as possible. That's the only point I'm saying. And again, it's not necessarily an invalidation of an electoral regime per se, because they have many, many virtues, especially in comparison to autocratic regimes. But we're throwing around this word democracy without realizing the radicality of it, of what it demands. That's all I'm saying. And I think in the 18th century, we sort of actually didn't go for democracy. We went for, liberal republics that we sort of democratized later on, but that cannot actually, I think, in my view at this point, amount to fully blown democracy. I realize I'm in the minority here, but.
Yeah, can I jump in? I know you guys want to
Tom,
speak.
and then I think Karen and Brad also want to jump in as well.
I know, so I just want to say one thing,
Right,
because it is relevant to one of Karen's points, which is, Hélène obviously has written a lot on sortition, these new ways of reinvigorating democracy. I think that her whole research program there, and it actually goes back to something Karen said, is that what democracy's core problem now is selling democracy. It's not that international law has to be sold. It's that because we can criticize our government so freely, there's just this malaise in a lot of the democracies. So that's the thing we have to figure out how to do, whatever mechanisms we actually use for doing the choosing. You can, back to you, Rob. You choose this.
Yeah, I want to let you, Karen, jump in, please.
I would say that the regional mechanisms, and this is why I was talking about the analytical change in Tom's argument, the regional mechanisms rely on sub-state actors bringing these cases to these international courts or appealing to these the regional legal mechanisms. The reasons why they don't work against the United States and China is because we've walled off, and China has walled off any ability of our domestic actors to use international law to maybe save ourselves. And that is kind of the story. Tom says to save yourself from a weak neighbor. But many of these cases, they're saving themselves from their own authoritarian leaders. And so I think Tom would agree that the inter-American system actually has been very robust, just not vis-a-vis the United States. It is a mechanism of using international law to realize the goals that you already committed to in international law. And that would be a democratic mechanism.
Brad, do you want to jump in as well?
Yeah, just very briefly I have to respond to Susan's point about Venezuela in the sense of just pointing out how bad things really were when Hugo Chavez said those things in the 1990s. And people forget, for example, the Caracazo in 1989, where perhaps as many as 3,000 people were killed by the security forces of a democratic state, as it were. There was a two-party duopoly in Venezuela that pretty systematically dealt out of participation, both with respect to actual popular will, but also with respect to benefits, huge swaths of the population. And also the people who were supposedly great defenders of constitutional order in Venezuela ended up perpetrating this coup attempt in 2002, which did not exactly cover with glory those who had dressed themselves up in that kind of constitutionalist garb. All of which is simply to say that these questions have a kind of indeterminacy at their core that I think cannot be easily addressed by external standards. And that's the kind of space that I'm trying to establish here, with respect to international law's position on non-intervention.
Thanks, Brad. So we only have a few minutes left. We do have a question from Alice here in the Q&A. It's quite, it's a complicated question, so I'm going to try to distill it to something maybe, Tom, that you can take a bite out of in just a few minutes. So I think the nub of the question is basically whether the sorts of legal arguments that local actors make when they might try to, when they engage with international law, to what extent those arguments are derived from domestic regime constellations or from the way that these regimes are situated historically. So Alistair gives the example of the Russian legal community and how Russia's historical experience of humiliation and loss of empire has shaped its posture towards international human rights law. And I suppose, the question might be formulated whether this is sort of a general phenomenon beyond just the Russian case, sort of how those historical experiences and the way local regimes are configured, how those shape the way these states engage with international law. I think you're muted, Tom.
Forgive me. There's a lot there. I mean, I viewed that Russian psychology, which is super important for understanding Russia's international behavior, as being basically about international relations and not much about international law, right? Because we've obviously, in Russia's establishment of its, security zone, we've seen a couple things. We've seen massive violations of, rights of territorial integrity, which and sovereignty, which Brad defends so much. We've also seen, and it's worth, being fair to point out, that Russia's also tolerated democratic revolutions in its zone of influence, and I'm thinking of Armenia especially, so long as those leaders aren't, moving too much to the west. So I see it more of an international relations matter than a legal matter, but we can obviously continue that offline.
Okay, terrific. So we are right at 1:30. So I'm just going to wrap up here by thanking Sue Stokes and Kevin Cromash and the Chicago Center on Democracy for making this happen. Thanks also to our three terrific panelists for their incredibly thoughtful comments. And thanks, of course, to Tom for writing this absolutely terrific book that has given us a lot to think and talk about today. And thanks most of all to all of you in the audience for coming. If you haven't bought Tom's book yet, you must. We've really only just scratched the surface of his quite incisive and wide-ranging analysis. So thank you all for coming today. Thanks to Tom, thanks to the panelists, and please keep a lookout for more events hosted by the Democratic Erosion Consortium and also the Chicago Center on Democracy. We've got a lot going on, and we'd love to see you all at more of our events in the future.